The petitioner has filed the present petition, my lord, being aggrieved by the annexure P1, that has the notice been issued by the respondent number 2, my lord. Although the controversy involved in this matter, my lord, can be gathered, if your lordship permits.
What notice has been issued?
My lord, under section 145 of CRPC, claiming the property in question has been disputed by both the respondent number 1 and the petitioners. And with respect to that, my lord, I just humbly submit two things, my lord.
To file reply to the notice?
My lord, we have already filed a reply, but there's a generic question involved in this dispute is with respect to the possession of the property. If the possession of the property has been taken or from the respondent within 2 months from the date of the notice, then only then 145 proceedings can be initiated. This point has already been decided by the respondent number 2 in its earlier order.
Make all these file reply and state everything before the respondent number 2.
These things have already been brought to the knowledge of respondent number 2, and still on that basis, the respondent number 2 still bent upon to initiate the proceedings only with respect to the intention of taking the possession from the petitioner and handing over to the respondent number 1. I just humbly bring my lord's kind knowledge to only two replies that we have filed in this matter.
Where is the notice? First, let us see
the notice at page number 17, annexure P1.
Yes. Let us see the notice first.
My lord, थाना प्रभारी थाना नगर द्वारा इस्तिगासा क्रमांक 1/2022 धारा 145 का प्रस्तुत कर अवगत कराया गया है कि दिनांक 17/7/2022 को बगीचा मोहल्ला स्थित 17/40 का आवासीय भूखंड स्थित है। आवेदिका माया पति सोइंसो का उक्त आवासीय भूमि का कब्जा तहसीलदार भाबरा के द्वारा दिया गया था। उस आदेश को निरस्त किए जाने के कारण अनावेदिका फिरोजा द्वारा निर्माण कर कब्जा किया जा रहा है। दोनों पक्ष उक्त भूमि को अपना अपना बता रहे हैं तथा अपना अपना कब्जा होने के दावा कर रहे हैं। इस आवासीय भूखंड को लेकर दोनों पक्षों में काफी तनाव बना हुआ है। इन दोनों पक्ष हिंदू मुस्लिम समुदाय के होने से सांप्रदायिक झगड़ा होने की संभावना है। This is the impugn notice, my lord. And first of all, my lord, in 2019,
yes,
that is annexure P2, a written complaint was submitted by the respondent number 1 to the collector. That complaint was forwarded by collector for proper disposal to the SDO, that is the respondent number 2. On receipt of that complaint, SDO issued us annexure P2 notices and called.
It was issued in
2019. I'm referring the matter start from the very beginning when the dispute was arise between the before the authorities.
Where you have filed reply before the SDO? Pursuant to this notice.
That is not on record, I'll submit that reply.
File reply to the SDO.
We have already submitted
at this stage, we can't assume that the subdivisional officer has personal prejudices or bias with you.
I can demonstrate this thing only from the documents and the order passed by SDO only.
First argue before the SDO.
My lord, I'll just submit one more thing, my lord.
Yes.
My lord, this 2019 proceedings went further and annexure P4 page 24, my lord. Annexure P4.
First,
I just demonstrate on this part what is the intention of the SDO with respect of initiating these proceedings. Page 24 is the report that was submitted by the SDO to the collector that with regard to the same dispute that arose between the parties in 2019 at page number 26. I just humbly read the last paragraph of that report. तहसीलदार प्रतिवेदन मुख्य नगर पालिका अधिकारी के प्रतिवेदन एवं अनावेदक द्वारा प्रस्तुत जवाब का अवलोकन किया गया। दोनों पक्षों के समक्ष में सुना गया एवं समक्ष में समझाइश दी गई कि स्वत्व संबंधी विवाद होने के कारण संबंधित को सक्षम न्यायालय में स्वत्व निराकरण की सलाह दी गई। In 2019, he appointed to both the parties that it's a title dispute. Though both the parties may approach the civil court. One thing, my lord. Subsequently,
no order under section 146.
No 250, no 145 was passed at that particular time. After that, in 2022, the respondent number 1 again submitted an application disputing this fact that the possession is with the petitioners. That application was filed before the Tehsildar. My lord, that order is at page 27, annexure P5. Tehsildar, ignoring the earlier orders passed by the senior authorities, the finding recorded by Tehsildar is with respect to section 250 of MPLRC and directed that.
First, go and file reply.
I'll file the reply, my lord, and we have brought all these things before.
We will ask him to decide your objection.
We have already brought all these things into knowledge of the SDO, and even
Ah,
after getting a
where is
reply, my
that?
lord,
Where is that?
I'll file that reply before this honorable
देखिए
court, my lord.
श्री आयुष्मान चौधरी learned counsel for the petitioner, Sri Garg Aditya Garg, government advocate for the respondent number 2. The present petition is filed against the notice dated 18/7/2022 issued by the respondent number 2 under section 145 of the CRPC. Counsel for the petitioner submits that earlier also proceedings under section 145 were initiated against the between the same parties, and the matter was finally decided by the respondent number 2. He also refers order passed by Tehsildar dated 21/4/2022 in revenue case between the parties. However, the present petition is filed only against a notice issued under section 145 CRPC. Therefore, I am not inclined to entertain the present petition. However, the liberty is granted to the petitioner
My lord,
to submit a reply to the notice along with the relevant record before the respondent number 2, and if the reply is submitted before the respondent number 2, the respondent number 2 shall consider and decide the objections raised by the petitioner before proceeding further in the matter. With the aforesaid liberty and direction, the present petition is disposed
my
of.
lord, with at least the petitioner may be granted a breathing period of 7 days.
No,
in
nothing.
Case, my lord, the reason
Possession
being,
dispute
my lord,
है.
possession disputed नहीं है. Even the SDO has decided in this earlier. My lord, only one more.
145 very purpose is defeated. We don't know unless there is no finding.
My lord, there is a finding. My lord, only one simple annexure. My lord, annexure
Point out
P7.
him. Point
This is
out
the
him.
order passed by the SDO
It's
itself.
only
my lord.
against a notice, Mr. Chaudhary.
My lord, P7 में SDO के सामने.
There appears to be a dispute of possession between the parties.
My lord, that has already been decided, my lord.
Go
P7 में ये जो order हुआ
Why don't
तहसीलदार
you
का,
go to civil court?
my lord, we
Get
have
it.
all my lord, we are already in
And
the possession
decided-
since 1974. Even that document has been
We will
admitted
not
by the
interfere.
SDO.
At this stage, we will not interfere.
My lord, at
Go
least a
and,
breathing period.
go
my
and file reply before the authority.
My lord, we have already filed a reply. I'll place that reply before this honorable court, my lord.
He will decide that if you have already
My
filed.
lord, at least a breathing period of 7 days.
No, no, no.
My lord, they will unnecessarily will dispossess
We
me
don't-
and might even appoint a person to hand over
We
the
don't
property,
know-
my lord.
We don't know the exact position.
My lord,
of
at least
the
a 7 days,
possession.
just because at least a
No,
7
no,
days
sir.
period, so that both the parties, if required,
No,
they could
no.
approach the civil court or this honorable court, my lord.
That would amount interfering at this stage. He has simply issued a notice. He has not even passed a preliminary order under section 145. You have come straightway in the writ petition.